South 40 Solar calls Ken Nolan as a witness. Ken, can you state your full name for the record, please?
I'm sorry, I should swear.
Nolan.
I need to swear you in first. Mr. Nolan, do you swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Ken, would you state your full name for the record, please?
Kenneth A. Nolan.
And Ken, did you pre-file direct testimony in this case dated August 14th, 2015?
I did.
Do you have a copy of that with you?
Yes.
Are there any corrections that you need to make to that testimony?
No.
Is it true and accurate to the best of your knowledge?
Yes, it is.
And did you also, at the same time, pre-file Exhibit KN-1, your resume?
Yes.
Ken, did you also pre-file supplemental rebuttal testimony dated April 25th, 2016?
Yes.
And do you have a copy of that with you?
I do.
And do you need to make any corrections to that testimony?
No, I don't.
Is that testimony true and accurate to the best of your knowledge?
Yes.
And in connection with the supplemental testimony, did you pre-file Exhibit KN-2?
Yes.
With that, I would move for the admission of Mr. Nolan's direct testimony, pre-file rebuttal testimony, and Exhibits KN-1 and KN-2.
Any objections?
None for me.
No.
Thank you. So admitted.
Mr. Nolan admits it for cross-examination.
Mr. Sicki, do you have questions for Mr. Nolan?
I do not.
Mr. Einhorn?
No, no questions.
Mr. Lesher?
Yes, I have some questions.
Thank you.
I'm going to distribute the exhibit. Mr. Nolan, if you could please turn to page 189 of the Comprehensive Energy Plan. We will be looking at that exhibit, which is started at the pages 9.3, current electrical supply.
I'm sorry, Mr. Lesher, do you have copies of the plan with you?
I do.
You have a copy of one page from,
This is an extract from
The report?
the Comprehensive Energy Plan.
and do you have copies for the parties?
Madam Hearing Officer, BDS.
Yes.
Do you have a copy of the,
One moment.
did Mr. Nolan have a copy with him? of the report?
He does. We give
Okay.
him the entire plan. He's just getting to the page.
Okay. Section 9.3, current electric supply. I have in front of me.
Great, okay.
Mr. Rob Vogel has a,
Because I don't want to be disruptive to the cross-examination, but I think there's again a fundamental issue, which is that any cross-examination of this witness needs to be within the scope of Mr. Lesher's intervention and needs to be within the scope of this witness's testimony. This witness's direct testimony related to the need for the project under B2 and IRP planning under BE6. His rebuttal testimony addressed issues that Mr. Hopkins raised about the PPA and addressed one issue that Mr. Lesher raised concerning BED's sale of RECs, although he noted in his testimony that the issue seemed to be irrelevant to this proceeding. So I raised to you just the general question or statement that BED's, whether BED should or shouldn't have entered into this arrangement and is not the subject of this proceeding. The board is not approving the PPA. That is not the scope of this 248. And Mr. Lesher is limited to, per your order, municipal and regional planning under B1. Mr. Nolan has not testified at all about municipal or regional planning, nor has he testified about the comprehensive energy plan. So at the outset, it is difficult for me to understand basis for questioning him on this.
Mr. Lesher, could you explain how your proposed questioning fits within the scope of your intervention and Mr. Nolan's testimony?
My questioning will be related specifically to VLS-3, SFSJL VLS-3, which is the Vermont Law School report, which Mr. Nolan refuted in his testimony to my direct testimony, in his rebuttal testimony to my direct testimony. I will not stray beyond that, so I submitted my initial exhibit, but it is part of the record, and Mr. Nolan's rebuttal of the direct testimony that I submitted is related to that VLS report. So I'm really just exploring the source of the information for the statement that was quoted by me in from the VLS report, and I'm just asking for Mr. Nolan's review of the source of the information, which is from the Comprehensive Energy Plan, which Mr. Nolan has in front of him. So my goal here, as it relates to municipal and regional development plans, again has to do with the renewableness of this power and the assertions by the folks proposing this project that this power is in fact renewable. And the question we will be discussing is the graph which illustrates the amount of power that is part of Vermont's power portfolio after REC sales. So I find it interesting that this project has been proposed as being renewable, yet we can't discuss RECs. I understand that we're not talking about BED, we're not talking about the contract itself, but there is, seems two versions of renewable. There's the little letter renewable and the big letter renewable. And the renewables that count are the big letter renewable, and basically we can't talk about those. But all of the regional plans and all of the municipal plans are asking for improvements in the renewable energy portfolios that are in their communities.
Could you then perhaps identify the statement that Mr. Nolan made in his response to your submission?
Sure.
And then I think, again, the gist of your question is to ask Mr. Nolan whether his statement, as provided in rebuttal, is changed with knowledge of this source document.
His rebuttal statement was the Vermont Law School report Mr. Lesher quotes is a non-peer-reviewed, student-prepared report that is not accurate. So he disputes the report as being accurate. And I just wish to have him comment on the source of that information that was cited by that report, because the source of that information is the Vermont Comprehensive Energy Plan. And so I wonder why he can call his peers in the industry, Vermont Comprehensive Energy Plan's authors, inaccurate.
Would you like to comment?
Sure. We're still back to the problem, which is that the VLS report itself is irrelevant. The fact that Mr. Lesher brought it into his testimony doesn't make it relevant. And it certainly doesn't make it relevant for purposes of municipal and regional planning. B1 says that the board shall give due consideration to the land conservation measures of a duly adopted municipal plan and to the recommendations of regional and municipal planning commissions. There's nothing in the face of the statute or in board case law that would suggest that any goals that might exist in those planning documents with respect to greenhouse gas reduction pertain to the specific project and would give rise to a debate about whether this project is renewable or not. It doesn't mean that you have to measure its compliance with B1, because it's simply not the kind of provision that the board has ever found to be one that a project has to comply with. That is a mandatory provision. So I just think we are very far afield. Obviously, if the hearing officer wants or rules that Mr. Nolan can provide an answer related to whether he changes his testimony, then I think that will speak for itself. But I do feel, and we'll make this point in the briefing, that at the end of the day, whether Mr. Lesher is right or not, it is still not the issue that is before you in deciding this case.
Thank you. Mr. Lesher, what I don't want to see happen here is to go further in trying to validate this VLS report. But if you can clarify or rephrase your question so that it is targeted at what Mr. Nolan has testified to as it relates to your interest in orderly development. in terms of Burlington city plans or regional plans, please do so.
Okay, I will attempt to do so, and if I fail in that, please give the answer whatever consideration you think it merits. I will leave it to your judgment to determine what to do with any answers that develop. So,
Thank you.
Thank you. So, Mr. Nolan, in your rebuttal testimony, you contradicted the following statement that was included in the direct pre-filed testimony of John Lesher and in the exhibit SFS-JL 3VLS Energy Clinic report on REC's final for SNRE. Quote from the report, according to the Vermont 2016 Comprehensive Energy Plan, Vermonters receive 0% of their energy from solar and wind sources. Vermont's electric sector greenhouse gas emissions have approximately doubled over the last decade, partly due to flawed renewable energy policies. Your rebuttal was the following. The Vermont Law School report Mr. Lesher quotes is a non-peer-reviewed, student-prepared report that is not accurate. The source of that information in that report was presented in that exhibit, SFS-JL 3 VLS Energy Clinic report indicates the source of that information was the 2016 Comprehensive Energy Plan prepared by the Vermont Department of Public Service. Please review that page 189, and the graphs on that indicate on the right-hand side the amount of power from each type of power source that is part of Vermont's energy use portfolio after REC transactions. Keeping in mind that the regional and municipal development plans of Burlington and Chittenden County both are seeking to increase the amount of renewable energy in their particular geographical areas, how do you respond to the graph's illustration that there is no power from solar and no power from wind in the whole state of Vermont after REC transactions?
Ken, before you answer, that was a mouthful. I don't know. I mean, there was a lot of testifying by Mr. Lesher as to certain facts that may or may not be in evidence, and I think it was a compound question, so I'm not sure that was really an answerable question. It also presumes that when Mr. Nolan made the statement, the report is not accurate, it doesn't specify what part of that report is not accurate. So there's been no foundation to even determine from Mr. Nolan what he was referring to before Mr. Lesher has jumped to connecting the dots between the VLS study, the Comprehensive Energy Plan, and the municipal and regional plans. I think it has to be unpacked a little bit.
Mr. Lesher, does this page of this document show up anywhere else in your testimony or attachment to this?
No, it does not.
All right, I'm going to ask a question. Mr. Nolan, do you have the plan in front of you? And
The Comprehensive Energy Plan?
yes, page 189.
Yes, I do.
Could you explain, just for clarification of the record, what adjustments for REC holdings means in this context of these graphs?
But my rebuttal testimony, when I state that the VLS report is inaccurate, I wasn't specifically referring to the graph in the Clean Energy Plan. Although I would point out that the DPS Clean Energy Plan is a very aggregate document that doesn't capture a lot of the nuance that occurs in an individual utility. But my statements regarding the VLS report are more in line with their conclusion, and the comment that Vermont's renewable policy is flawed, and I believe that is inaccurate.
And my question, because I actually personally want to understand this a little better, is what exactly does the adjustments for REC holding show in these graphs? And I know these are not your graphs and you are not testified to it, but in the context in which Mr. Lesher is asking his question and in which you have testified, I think it could be helpful.
Certainly. So I guess the best way to describe this is in the context of net metering and standard offer, for example. The standard offer, I know for a fact that Burlington Electric has retired RECs from some of the standard offer projects. which include solar, because we have done that. They're in such small quantity that it's not worth transacting those. There are customers, although there are a few at this point, there are customers who turn over their net metering recs and have those retired. So in an aggregate from a utility scale, I think the graph in the Clean Energy Plan is accurate, but it is not accurate to say there is no solar and no wind in the renewable portfolios. And that can change from year to year, and depending on what each individual utility makes for decisions. And then certainly historically, if you actually look at utility by utility, you will find solar and wind energy being retired in addition to hydro. We've retired some of our McNeil recs in the past, depending on what's happening in any individual year and what the economics look like.
Mr. Lusher, does that help respond to your question?
It does address, he's describing that BED has retired some recs from net metering projects. And so in his rebuttal testimony, he asserted that 6% of Vermont's power was from renewable sources. And I'm going to second guess that 6% represents the 100% of Burlington Electric. Would that be correct, that 6% was 100% of Burlington Electric, which is counted as renewable because of their REC transactions?
Am I allowed to answer that question?
Yes.
Yes.
I guess I have a standing objection that this continues to go too far, but.
Okay. My reference to the 6% in my rebuttal testimony was, in fact, referring to 100% of Burlington Electric's load. We represent 6% of the state retail sales. And after REC transactions, we do retire RECs equal to 100% of our load. It's a combination of hydropower, some solar power, some wind power, and some biomass power.
Thank you. Next question, Mr. Lusher.
To replace the RECs that are sold out of state, do you purchase null power or get credited for null power from the ISO New England management when you sell a REC to Massachusetts?
I'm not familiar with the null power term.
It's also referred to as uncovered renewable.
Yeah, again, so the way Burlington Electric manages its REC portfolio is we sign long-term contracts with renewable projects for bundled power, which includes energy capacity, RECs, and to the extent they qualify in the reserve markets, we get the right to that reserve revenue as well. We sell off RECs from those bundled products, typically to Connecticut and Massachusetts, although we have sold in other markets. And then we buy back RECs from other generation, typically small-scale hydro in Maine or Connecticut, equal to the amount of RECs we get sold off from the bundled products. So the wind or solar that we sell in other states, we buy an equivalent amount of RECs from hydropower to offset those sales. But those transactions do not occur through ISO New England. They are direct bilateral contracts with the other third parties.
Okay, thank you. So for this project to be considered renewable with respect to any state or regional or community plans, the RECs would have to be retired by BED or another power entity within the state of Vermont. Would that be correct?
I'm not prepared to say that in actuality.
Mr. Lusher, I think we're straying into an area of
Yep.
trying to interpret the REC market.
Okay.
And it goes a little bit beyond the scope for this purpose.
All right, that's the end of my questions then.
Thank you.
Thank you.
you.
Thank you, Mr. Nolan, that was helpful to me.
Isn't that it?
Do we have any other parties with questions for Mr. Nolan?
No?
Do I move for that cross one to be entered into the record?
Yes, go ahead and move.
I'd like to make a motion to enter cross one into the record.
Any objections?
Excuse me for a moment. Madam Hearing Officer, this page is from the 2016 Comprehensive Energy Plan. The time that the application was filed, this plan was not in effect. And I believe under vested rights law, it is the plan, it is the regulations law and plans that are in effect at the time a complete application is filed that are germane to the application. So I think on its face, this page from a plan that is not the plan that's before the board, in this case, is irrelevant and should not be.
So your position is that the board should not be looking at the current plan in assessing a project that's before it at the...
I would reverse that. My position is that when the board looks at the law that applies to a particular project, it looks at the law, the regulations, and the plans that are in effect at the time of the application. There is case law, for example, that a regional or town plan that had changed during the pendency of a proceeding are not the ones that apply to that 248 proceeding, and I think the logic would hold. When you look at whether this project complies with the comprehensive energy plan, you need to look at the plan that's in effect at the time you file the application in August. And on that basis alone, setting aside other problems here with relevancy and hearsay, I think this should not come in.
I'm going to allow it in for the elucidation that it gave through Mr. Nolan's response to how the BED works in the rec market, to some extent at least. So I will allow this in as SFS JL Cross 1. And this is an excerpt from the 2016 Comprehensive Vermont State Energy Plan. And it will get the weight that it deserves.
Yep.
Thank you. Petitioner has no leader from Mr. Nolan.
I guess that's no more questions for Mr. Nolan then.
Okay, Ken, you're off the hook.
Thank you for allowing me to call in.
Thank you.
Thank you.
Mark. Oh, sorry. I'm sorry, I didn't see you there.
Can we just go off the record here for a second? First, you have to apologize.
Yes. Sorry.
I don't know what you were really doing. I mean, I think we were operating with something new right after.